compensation, excuse me. And at that meeting, there was more information that the commission needed, and perhaps we weren't in a position to present all of it at that time. The effort today is to bring some people in and better explain what's happened since this issue has started and where we're going with this, in an effort to provide more information and answer more questions today. So that's why we're here.
That's fine.
So we have our workers' comp attorney here to explain why the process, why legally got slowed up, and where we are, and what can we do.
Just as long as it's in a tone, in a manner of not finger pointing, just education.
Oh, no, it's education too.
That's the effort. All right. Yes, sir. Welcome.
Good morning, Commissioners, Council, Mr. Baird. My name is Mark Hill, and I am an attorney. I'm, in fact, the outside attorney that the county uses for defense of the workers' compensation claims. Just by way of early apology, there's nothing that occurred this morning that isn't imminently more exciting than workers' compensation. But workers' compensation is a system that we all have and use in our system. The workers' compensation system has been around a long time. It's supposed to be a self-executing system. Somebody gets hurt in scope of their employment, and workers' compensation kicks in. When that works, it's great. When it doesn't, it's bad. And that's what ends up in litigation. If it worked always, every time, I would not have a job and you would not see my face. But that's just not how the process works. The law of workers' compensation is a very, very specialized area of the law. And it requires certain things to be presented in order to process through the system. We are not in a normal litigation system. We don't go in front of county judges and circuit judges. We go in front of workers' compensation judges. And in fact, you guys may not even know this, maybe you do. Our workers' compensation judge for this district sits in Sebastian. Most people I say, who, what, where? I actually worked for the state for 4 years. I was the state mediator in Sebastian. We handled, I should say, all of the workers' compensation claims for Okeechobee, Indian River, and Brevard County. One judge, one mediator. We did them all.
In Sebastian.
In Sebastian.
Thought we wasn't tourist tax dollars.
It's on US 1. Our state office is on US 1, just north of the Wendy's, on the east, on the west side.
Well, who's the, you know how to say the judges?
Robert Dietz. Okay?
Well, this should go really quick.
Why is that?
Well, if he's only in Sebastian.
There are a lot of timelines that are mandated by the workers' compensation law, requirements of how quickly any given claim must move through the process. And obviously we have our own, because we're out of the constitutional law process, we have our own rules and procedures that we're required to follow. Some of them are fairly generic, some of them are very specialized. As it applies to the cases involving the fire stations, and as it applies to really any personal injury case or any other case where evidence is involved, when you are the possessor of the evidence, you have an obligation, once you're put on notice, to preserve the evidence. If you do not preserve the evidence, you run into what's called a spoliation claim. In other words, by destroying evidence, you extinguish the ability of either side, claimant side or defense side, to gather the evidence that they need to proceed with their case. In this instance, when claims started to come in terms of exposure, as the claims were awarded, as exposure to moldy toxic substances, we were at that moment required to preserve the evidence, which was why my predecessor at my firm, Paul Westcott, advised the county, look, we can no longer remediate these. We are under an obligation to preserve the evidence. In personal injury, it might be a car accident, and it's the car that's the evidence. You cannot take that car and destroy it. You have to preserve it. So that's what occurred in this scenario. And that's not just for us, that's as much for the injured worker side to have their ability to move forward with their claim. And so we were put on notice, not just at the beginning, but again, about 2 weeks ago from Jeff Bittler, who's the attorney for the claimants in this case. And the notice came by way of a letter to us: do not destroy the evidence. If you destroy the evidence, you will face a spoliation claim, which means they will have other legal remedies. And in essence, even if we have a valid legal defense to these claims, we will probably lose that defense. Okay? So we have an obligation to preserve the evidence, and that's what occurred here. As a result of that, and that started November-ish, okay, when we first started getting involved in that, and that's when we said, hey, we've got to put the brakes on this so that we preserve this. As a result, there have been negotiations going back and forth between my firm and my predecessor, Mr. Westcott, and Jeff Bickler's firm about defining the scope of what these inspections mean. Because frankly, when you get into mold and toxic substances, this is not black and white. This isn't an MRI of a torn rotator cuff. This is complex stuff. So defining the scope of inspection became a difficult and complex process that our experts, actually initially their experts presented a scope. Our experts thought that that scope was significantly too broad. Our experts came back with a different scope. And it took us, unfortunately, it took us until a few weeks ago to agree to a scope. There was some judicial involvement in it originally in terms of allowing the inspections, but then ultimately we were able to agree to a scope of inspection, and that was reduced to a stipulation and a court order. Just to give you the date of it. The court order is dated March 18th. And in that order, it adopted our stipulation for the scope of the inspection, as well as our time frame. And the time frame is stipulated based on the availability of the experts of both the claimants and of the county, that we were able to coordinate an inspection date to start on March 31st, next Tuesday, and go 2 days, 3 if necessary. And again, that stipulation was reduced to a court order, and we are all required to abide by that court order. Now, having said that, based on what I understood occurred on Friday, we got a hold of our expert and said, are you able to come here next week? And basically our expert said, no, I'll be in Canada. I then in turn got a hold of Jeff Bittler and said, Jeff, what is your availability? He said, well, we're meeting with our expert on Monday morning. I'll call you right after that. And I will tell you that their attorney and I have worked very closely to try to get this done. We have the same interest in getting this done as quickly as possible. So he and I talked yesterday after he met with his expert, and he said, Mark, I cannot get my experts there this week. The earliest they can get there is on Tuesday when it was arranged. So I said, okay, I just want to make sure that we're kind of on the same playing field. So that's where we were left in terms of the inspection process itself. So I guess the first thing I need is just kind of open up. Any questions about that part of it to this point?
Just go ahead. Just think about it. I'll give you the opportunity.
One, it took them almost 40 days from December 18th when they requested an independent test, December 18th to January 26th, before they even submitted their first outline of what their scope. So I'm looking at this as, what if the sheriff decided to empty his evidence storage locker and all the weapons and guns that were in there, and he said, just lay them out in the lobby for now, and somebody walked in, picked up one of these guns, and started shooting the deputies, and so now you got a workers' comp case. What you're saying is, according to this, the sheriff would have to leave all those guns laying out in the lobby for 3 months before the attorneys could decide, yeah, we need to come, to a resolution here. To me, it's absurd and unheard of, and it would be a total of 3 months from December 18th to March 18th before we got a court order to move this forward. And again, I think that's absurd and ridiculous. Okay? It seems to me that if the claimant wanted this information, it should have been up to them to expedite it, and so we could bring this to a resolution. And you know, I understand what you're saying, that there's legal repercussions, but, you know, the only thing I can say is, make sure our guy is there on the 31st, and if their guy ain't there, then we're done. I mean, to me, this is totally ridiculous. It's taken 3 months to get to this point, okay? And it just boggles my mind that we can't get this thing done and address it. So, you know, March 31st, just make sure our guy is there, and if they don't show up, then that's it. They have their chance, court order or not, or whatever, no excuses, nothing. We get it done. I don't know, this is...
I feel you're disgusted, and it's one of those things, we can't defend it. And so, whenever I can't defend it or explain it, it's time to change it. And so, I agree with, I mean, I'm looking at the time frame here, and the scenario that you used is about like, you know, leaving the middle of State Road 60 exactly that way for 90 days until everybody gathers their evidence and does what they need to do for court. And I understand what you're saying, but you wouldn't do State Road 60 this way if it were an accident.
I have a question, just to make sure I'm following everything correctly. So this timeline, and is this, we probably need to make this timeline available, or copies of it available to those who want to look at it. So we have December 3rd, county receives first workman's compensation claim alleged indoor air quality issues at Station 10. Then on 15 days later, claimant's attorney requests that the county allow them to conduct independent inspection tests at the stations. So from December, this is the union's person. What was his name again?
The tester?
No, their attorney.
Jeff Bickler.
Jeff Bickler?
Correct. GEOFF.
Okay, so on December 18th, they say they want to test, but it takes them a month, not quite a month and a half, for them to send a scope to us that includes that they want to test for bed bugs. I don't know if that has to do with mold. Noise decibel test, what does that have to do with mold? Structural analysis and testing, what does that have to do with mold? I don't see the relevancy of why they threw all this in. If they wanted to get the mold test, they just should have said mold, you know, period. We would have been December 19th probably, not January 26th. So I see why, so that we got into the back and forth between sides. Those things are not relative to the mold, so you had to go back and forth to get the scope modified. So we actually, who went to the judge to get the STIP entered that said the testing will move forward with just the mold? Did we do that?
Recently? Yes, I filed a motion for protective order and a motion to define scope of inspection.
So we took the initiative to move the mold testing forward and not keep this back and forth.
That's correct.
So that's good. Now,
I also would like to point out to the public that we did, as soon as the stations, we got complaints. That's why we have September of last year. We did testing for mold in all those stations. That's why you've got, and the commission really needs to read those mold studies.
also, it looks like in the pictures that since the remediation work was started, cabinets were removed, at least in some of the pictures. It looked like wet areas behind maybe where the sink was or a faucet or valve or something was. So that was, I don't want to say covered up, but it was covered by the cabinetry, or I don't know, what was one of them, a kitchen area where that, in the picture it looks like there's a pipe and some stuff coming out of the wall, that there might have been something installed in there.
Yeah, I'm not exactly sure.
That's a union picture. We don't know where that is.
Okay. All right, so now we've got it down to the mold. Now, is this the swab test that they asked for, or are they going to revisit the indoor air quality over a series of days where the space has to be closed off for indoor air quality?
Let me explain the inspection process,
Okay.
as best as I understand it, not being a scientist. There will be a small variety. We've narrowed it down to 5 subject areas that they will do their testing on. But essentially, there's going to be air trap that detects spores in the air, along with some physical testing where they use typically tape to remove samples. Okay, how they're going to do it? Understand that I don't control fact that they're not allowed to use any destructive measures. How they actually do their testing, I don't know. I've actually requested that so that our expert who's going to shadow their expert will be better prepared for that. But I can't control that. They can do their testing the way they want to, so long as they're not destructive. Time frame, both sides assume that it should be able to be completed in 2 days. 2 stations on Tuesday and 2 stations on Wednesday, about 2 to 3 hours per station. The only reason we also reserve Thursday is if some unforeseen event occurs, weather, whatever. The air sampling, and if you, I think you've been supplied the 4 test results from AMAC that have already been done. When they do air